every Tuesday from 5 to 6 p.m. Central Time. Along with me is my business partner, Emily Neumann. Emily, what do we have today to discuss?
Yeah, today, one of our presidential candidates, Vivek Ramaswamy, was making some headlines announcing that he was going to gut the H-1B program and end it because it's terrible and all those things. So we want to talk about, can he actually do that if he were to be elected president? We also have a potential issue coming up October 1st, 2023, is right around the corner, is a possible government shutdown due to the inability of Congress to come up with a continuing resolution or decide on a budget that will keep the government operating. So we'll talk about what everyone needs to know, how that government shutdown, if it happens, would impact the different types of cases and applications that you may have going on. We also want to talk about age-out kids. What is the impact of this employment-based immigration backlog where the priority date cutoff dates are not moving? We're still in 2012 at this point, even with the new fiscal year. How does that impact kids that are potentially aging out? What can you do to help prepare your kids for that? And then PERM delays, those are continuing. What do you do if your H-1B is nearing your 6-year limit? What's the action plan for that?
Emily, we have this Indian candidate who is a presidential candidate, and he's doing a little bit better in the polls though, compared to where he started though. But he started this anti-H-1B campaigning and saying that he can ban. And I see very similar characteristics in Trump when Trump said immigrants are undesirable people of the United States. Can the president of the country unilaterally ban the entire H-1Bs, take the H-1Bs off? Or does it require for him to go to the Congress?
Yeah, there are certain things that the president does have the power to do, but he cannot change law that's been enacted by Congress without Congress. So to say that he's going to unilaterally end the program without congressional help to do that is not possible. So that's a good thing. He can't do that on his own. There are some things that a president can do to the H-1B program, and we saw that under Trump. He can change regulations about prevailing wages, how those are calculated, and what order the lottery is conducted in. He could change some of the memos. We had some issues with the deference to prior adjudications that Trump eliminated, which caused a lot of RFEs and denials on extensions, causing a lot of people to have to temporarily leave the country, but he cannot completely eliminate the program. Why do you think he's, talking about it so much as a presidential candidate?
Well, he just wanted to gather the votes of the conservative Republicans that are the right-wing people who are anti-immigrants, though, as just what Trump did it when he wants to come to power. He's just wanting, it's a primary season, though. The Republicans move more towards the right side, though, trying to attract more conservative Republican votes. But once they come to the election, they try to move more towards the left side, though, not to the left side, to the center side. So to get the nomination, though, they need to probably speak that way, I guess. I don't know. But they're trying to speak only to gather the votes of the Republican Party. Now, of course, I don't see this guy as an immigrant-friendly guy, definitely. I don't see this guy, even though his parents have come on the ladder for which he just wanted to remove that one from where he's actually come from, where his natives come from. We see that very tendency that just because the candidate is an immigrant doesn't mean that they're going to support the immigration though. Time and time again, though, if you look into history of the kings and queens, though, some of those people that came from one country and became a king of the other country didn't do the favor to their own country which they came from. So that's been there in European history for a long period of time. And there is a theory that they say in the German theories that people try to take the ladder off, the ladder that what they climbed or what their ancestors climbed. They want to take that ladder off so that nobody else can develop through that ladder. Seems to be the policy of Vivek Ramaswamy at this point of time, because he has come to such a very great stage where he can become a president of this country, and he wants to remove the ladder for those people who are aspiring people who wants to come into this country, whose children can become like him, but he just wanted to take the ladder off. I'm very disappointed with him. But just for the people to be aware of that, just because the president wants to remove the H-1B, he cannot. He has to go to the parliament, which in USA we call it as Congress. Now, it's very, very, very unlikely just because this guy becomes the president, the Congress is going to be in his favor and vote in his favor on the immigration matters. Very unlikely, though. For that, it requires 60 vote in the Senate, which I don't think so it's possible. For that, it requires a majority vote in the House. Maybe it's possible in the House, but definitely not in the Senate, though. So very, very unlikely. Even if the Republican Party get majority in both the places, they still need 60 votes in its Senate, which is very unlikely. So even if this guy becomes the president, what he's saying he cannot implement without the support of the Congress, which I don't think so is going to receive it. So I don't.
Yeah, I mean, really, if you think about it, Biden did the exact same thing, but on the other side. His whole campaign was pro-immigration. I'm going to solve immigration. I'm going to reform immigration. Day one, I'm going to bring an immigration reform bill and we're going to pass it. Gets elected. Day one, he did have a bill for immigration, but we're, how many years in and we still have no immigration reform. He's stuck. He's asking Congress to help. They're doing nothing. So it works. It's the same thing on both sides. Both sides use.
Well, President Bush was also in favor of immigrants. He wanted to bring the immigration legislation. He wants to give all the people who are undocumented present in this country, at least most of the people, to give the green card, and all those employment-based green cards. He wanted to double them and not count the family members. Bush tried to do it. President Bush tried to do it. He failed. The same thing. Obama wants to solve the immigration problem. He failed. So just because Vivek Ramaswamy is speaking, don't be fearful about it. Even if he becomes the president, he will not have that easy saying in the Congress. Now, Emily, the major thing that we have, this is just a scary tactic. But now, as we're discussing that Congress is in a deadlock, they don't want to move forward. They don't want to move backward. Now, when it comes to the budget, we're not going to discuss about the budget. That's a major thing, though. Because of the financial crisis, so if they don't increase the debit limit, then the US government has to shut off some of the departments, though. Now, what is USCIS, which is immigration, is that going to shut off? Like, can we not file the H-1Bs, I-140s anymore?
The good thing is USCIS is mostly funded by filing fees. So they can continue to operate during a government shutdown, and they have historically done that. So you can still file I-129 petition for H-1B, I-539 for your dependents, I-140s, I-485 applications. They'll still process them. They may be at a lower level of volume just because they might have to eliminate some staff, but at least you can still file with USCIS.
What about the Department of Labor, Emily, filing the prevailing wages, the approval of the labor certification, PERM labor certification? What about the approval of the LCA to file the H-1B? We need to first get the approval from the Department of Labor, which is called as labor condition approval. What about all these three things, Emily?
Yeah, this is where we're going to have the biggest impact because DOL does get shut down when there's a government shutdown. Now, the last shutdown in 2019, DOL was not impacted because they had a separate funding bill that kept them going. But I think that ended in 2019 or 2020. So if the government shuts down, you will not be able to submit an LCA for the H-1B or for an H-1B1 if you're Singapore or Chile, or for an E3 if you're Australian. So no LCA for any of those can be submitted. If it's already been submitted but not yet approved by October 1st, it will not be touched. It will sit there, which means that you can't move forward with filing your H-1B with USCIS. So even though I just said you can still file your H-1B with USCIS, if you don't have the LCA, you can't. So if you are in a situation where your H1 is expiring in October or something like that and your LCA has not been started yet, it really needs to be submitted by like Friday of this week because it takes 7 days to be certified. That'll get it certified on the 29th of September. Then if the shutdown happens October 1st, you've already got your LCA and you're good to go. The other big impact.
I have an objection to what you said, Emily. You said if the H-1B is expiring in October, they have to file it by this Friday. Do you mean to say that, are you assuring that the shutdown will not continue until November if mine is expiring?
Oh, definitely not. No.
Okay.
Yeah, we don't know how long a shutdown will last. It's been varying lengths from a few, 48 hours to several weeks. So yeah, definitely there no guarantees that even if you're expiring in November, you'll be fine. But there's only so much we can do in these last few days before a shutdown happens to prepare.
And you said, Emily, this Friday is the last day to file the LCA.
Yeah, that's the safest because it does take 7 days to be certified. So that would get it certified by September 29th. Now, technically, you have till the 30th, which is a Saturday. But I don't know how many attorneys are going to be wanting to submit LCAs this Saturday to get them in time. So definitely try to get it done on Friday, the 22nd at the latest. So it can be certified by the 29th. That way you've got one extra day for wiggle room. So that you can still file your H-1B, H-1B1, or E3.
Emily, even if they get the LCA certified, they can wait to file the H-1B. They don't have to file the H-1B first.
Yeah, it's just getting the LCA in place so that you don't have to worry about it in the event that there is a shutdown.
And what about those people who got labor certification will not be approved? What will happen to them though? Will the labor certification be approved?
No, so that's the other side of it. In addition to LCAs, PERM labor certification will be stopped. So if you're getting ready to file, you will not be able to file in the event of a shutdown. If you've already filed, your case will not be approved. It'll just sit on hold. Now, that doesn't necessarily negatively impact a lot of people because the labor certification process is taking a year already. And so if it is still pending a year from now, that makes you qualified for the 7th year extension of H-1B time if you filed within enough time. So it's not a huge issue as long as you're able to file your labor. But if you can't file it, you have to worry about recruitment expiring. We don't know if there'll be a grace period that will allow us to file when the government reopens using expired recruitment. They have done that in the past, but they will have to announce it in the event of an actual shutdown. Other big problem is prevailing wages and also audits. So if you have responded to an audit, it's just going to be kept on hold. But prevailing wages will not be able to be submitted and they won't be able to be approved. So that's going to delay your ability to start the rest of the labor certification process.
Anything else, Emily, before we go to the next topic?
Nope, I think we can move on.
As we know that the October visa bulletin came in and the priority dates are not moved. In fact, not as expectedly moved. And the trend seems to be that if things remain as it is, the priority date movement beyond January of 2015 will take a couple of years or maybe 5 years. And after that also, to movement will be every year, it may be a month or two. That's what we're expecting the movement. So what is the side effect of this? That especially the kids who are born in India, who are here right now on H4 going to school, they will have trouble because once they age out, they cannot get the green card along with their parents. And they cannot remain on H4 after they become 21 years. So you need to train the kids from now onwards saying that, look, you are not a US citizen, you're here in a foreign country. So you have to program the kids, you have to educate the kids to be on there at a later time. You're not going to be there for them to help you to get the green card. We don't know how long you're going to be there in this country though. But if they want to be in this country after you left though, they need to be independent. We recommend that from all the teenagers that you have who are born in India, you need to request them to tune into the immigration news, which they are not accustomed to. And we recommend our channel, of course. We are one of the best channels that gives out every Tuesday all the updates. So we want the kids to understand what's going on in their life. So please have them stick to the immigration things also, just like the way you give them knowledge, all other knowledges, science, maths, technology, and all those things. They may need this they will need this immigration knowledge because they will most probably will not get the green card along with you. So they need this knowledge, and you must inculcate. Now, when we come from India, we know that, okay, we come on student visa, what do we need to do? We go and apply for the university, we do the GRE, we do a TOEFL or IELTS, and then we come into the United States. Once we come in, we know there is an OPT, we know there is a STEM extension, we know there is an H-1B, we know there is a PERM, we know there is an I-140. It's already there in our mind, it's there in our society that we roam around. But when these kids go to school, though, they're not going to school with the immigrants. They're going to school with the Americans, and they don't have that knowledge. They don't have the know-how, how to deal with it. So you might want to train your kids from the beginning itself. Like you won't get the green card. You will have to swim on the, if you want to stay in this country. So you may want to educate a little bit, give the poison a little bit so that they get addicted and they don't get, panicked at a later time. I don't know how to express the proper wording, Emily. Can you say?
Yeah, I think it is important for them to, be made aware earlier than what we would probably think. As you mentioned, you don't want them turning 20 and then learning all of this all of a sudden. That I'm sure can be quite a shock. So they have time to plan and to understand it in their head and be just prepared for that mentally and emotionally. I do recommend that they look into the group called Improve the Dream. That is a group of legal dreamers, that's college age kids that are advocating for relief for their situation. And they've been doing an excellent job of advocacy. They've been on Capitol Hill. They've been in congressional hearings. There's a lot of bipartisan support for them in Congress. So if we can get more kids joining that group, more kids, and they're also making people aware of the situation, and there's, safety in numbers. They can learn from other kids that are going through the same thing and have someone to talk to, because obviously, as you've said, the kids they grew up with are all American. They have no idea what issues immigrant kids face. I mean, most Americans have no idea that there's a 7% cap. They have no idea how many years it's going to take someone from India to get a green card. They're shocked when I tell them. And this is for people who are here legally and are contributing to our society. This is how we treat them. So they're not aware of it. And so it's, when you're that immigrant kid, it's hard to be alone. So join up with these other kids that are going through the same thing and get that support, as well as work on some advocacy to try to come up with some solution.
Especially for the paid internships and certain other things, they will definitely be not eligible. Unlike the other of their US citizen or green card holder kids, you may have to educate them on that part too. Yeah, I mean, you have pointed a very good thing. Instead of us telling them more and they telling the kids, the people who have grown up and are probably on student visa, they telling the younger kids probably will impact much better than lawyers like us. Of course, they all still need to listen to us because we still give a different news, how to do the H-1B, get the green card individually. But you're right. I mean, the elder kids speaking to the younger kids will be they'll be influenced very much. Anything else, Emily, before we go to the topic of the PERM delays? Oh, PERM delays.
Yeah, every day
Emily,
it's worse.
in 2007, when the priority dates became current in June and July of 2007, Emily, I have filed some PERM applications and got the PERM applications approved in 3 to 5 days at that point of time. When the priority date became current in July, we filed the PERM, we got the PERM approved, we filed I-140 and 485 together at that point of time. Within a span of 1 week, all this happened. Now they are adjudicating the PERM applications filed in October of 2022. Not only that, the prevailing wage is taking 8 months. So the total period, that prevailing wage 8 months plus 4 months of recruitment plus the 1 year, we are speaking about approximately 2 years, if not more, to get the labor certification approval. And people are not prepared for it. They are in the H-1Bs in first 3 years. Oh, we will do it in my second term. In the second term, I'll take it easy. I'll go to India. I'll go to Europe. And then they will try to do the labor certification. And here comes the possibility, which we see every single week. So many people contacting us saying that I am near the 6 years of H-1B. It's expiring in December of 2023, and my labor has been filed in February of 2023. I won't get the labor certification approval. What are the alternatives, Emily, that you suggest to them?
Yeah, it's definitely important to think about it earlier rather than later, because the earlier you realize that opens up the opportunity of using recapture time. So that's this idea of kind of taking some strategic trips outside the US, because every day you spend outside the US, you can recapture that time. So if you're talking about your 6-year limit is December 2023, and your labor was filed in February 2023, your labor will be pending for 1 year in February 2024. February 2024 is when you're going to be eligible to at least get a 1-year extension of your H-1B. So how do you bridge that gap from December 2023 to February 2024? That's where, if you've traveled here for 2 weeks, there for 2 weeks, here for a month, that's 2 months, and you can recapture that time. And at the same time you're recapturing that, you can then request the 1-year extension. You can combine the two, because you can show that by the time you hit your recapture time, your labor will have been pending for 365 days. So that's one option. And if you have the option, you can, if you don't have a valid visa stamp, you can still do that by traveling to Canada or Mexico using automatic visa revalidation. As long as your stay there is for less than 30 days, you can have some margaritas and then come back into the US to try to buy some additional time. So that's one option. You could potentially change status to H4 if your spouse is also in H-1B temporarily, and then switch back to H-1B. You could potentially change status to B2 and stay as a visitor, not working until you're eligible to get back to H-1B. Or you can, at the end of your 6-year limit, go outside the US and stay outside the US until either your labor has been pending for 1 year or your I-140 is approved. Then your employer can file an H-1B for you outside the US. You don't have to go through the lottery, because you've already been picked and you're filing an extension based on AC-21. And then once you get that approved, you go for your visa stamping, and then you can come back. Now you're good. Now you can keep extending based on either a pending labor or an approved I-140.
Especially if you're coming very near to the 6 years of H-1B, though, we want you to consult an immigration lawyer, not on 5 years, 11 months, and 25 days. Not that time. Try to consult an immigration lawyer at least 5 years and 6 months, not 5 years, 11 months, and 25 days. It's very hard. We won't have much options. Like what Amelia is pointing out, going outside the country, spending outside the country, negotiating with the company. What is more important in all these things is that your company should continue with the labor certification process. Whether you go to Mexico, whether you go on a B2, whether you go to India, for all these things, you will have to have your company cooperating with you in getting the labor and I-140 approval. Now, if you have the H-4 EAD option, though, for some people, Emily, there is an H-4 EAD option. They don't choose that option. They don't file it. If they are on the 5th year itself, though, and if they have the option of H-4 EAD, you should file the H-4 EAD option. Get the H-4 EAD. Now, on H-4 EAD, you can still file the PERM application. You can still get the I-140 approval. You can still switch back to H-1B at any point of time later on to H-1B. So H-4 EAD, if you have it, pick it earlier itself. And consult a lawyer way early, not at the last 5 days or 10 days. Anything else, Emily, before we go to Q&A?
I think we can go to the questions. So I have one from Ankit. He wants to know, I have an approved I-140 on EB-1C. After what point can I change employers without losing my EB-1C? So EB1C is specific to your employer because it's based on your employer's qualifying relationship with the company that you worked for outside the US for at least 1 year before you came to the US. That means the only time you can take an EB1C with you is after you have your I-140 approved, after your 485 has been pending for 180 days. Then you're eligible for AC-21. That's what allows you to move the green card process with you to any new employer as long as the new job is in a similar occupation to the one that you were originally sponsored for. So prior to filing the 485, there's no option to stay in EB1C. You can keep that priority date with any other company that files something for you, but you won't be in the EB1C category at that point.
Question with regards to EB1C. If the people who are reporting to me, they are in India, can I still file the EB1C application? Yeah, you can still file, even though the employees are reporting from India. There are some questions raised, but as of now, though, we're getting good number of approvals, even if your reportees are in India.
Mohammed wants to know if EB3 rest of world will move forward in the next quarter. We say so many times that we cannot accurately predict the visa bulletin. I do think that it should move forward based on where the date for filing chart is. So the date for filing is almost current for EB3 rest of world now. And that's the date that the final action should move to in the next 12 months. So we should expect to see that date moving forward on the final action date chart in the next quarter. Now that will depend on how much demand there is, how many people are filing 485s now based on the current cutoff date, how many people are getting the green card at the consulate through that process. So without knowing how many people are in the pipeline, we can't guarantee that, but based on where the date for filing is and how many applications are currently pending, I would expect it to move forward some in the next quarter.
Shama is asking this question. Is the 485, does everybody gets the 485 interview, or is it only random? Sham, it's only random. It's not everybody though. But we're seeing up to about 40% of the people getting interviewed. Now, somewhere in 2022 though, the percentages was very low. But right now the percentage has increased because I think so there are more officers, not many cases there for them to work on. And people ask me the question, if the priority date is not current, why are we getting the interview? Will they give the green card? Yes, even if the priority date is not current, they can interview you. But of course, they cannot give you the green card when the priority date is not current.
Jay wants to know, how do I change status from an I-485 EAD back to H-1B? So the only way to do it is outside the country. There is no change of status option from a pending 485 to a non-immigrant status. You can only change status between non-immigrant statuses while you stay in the US. So then it depends on, does your employer that you are working for already have an approved H-1B that you had before and it's not expired, and you just switched to the EAD for whatever reason and now you want to switch back? In that case, you need to have a valid advance parole. You can exit, and then if you don't have a visa stamp, you need to get a visa stamp and then come back in on H-1B. If you no longer have a valid H-1B, if it's expired or if it's with a different company, then you need to have the company first file an H-1B petition requesting consular processing. Assuming your priority date is not current, they would use your I-140 approval to get a 3-year H-1B. Make sure you have an advance parole, then you can exit, apply for the H-1B stamp at the consulate, and come back in to regain your H-1B status.
Question of the day. Gorus asked this question from YouTube, that if we file the 485 application based on the dates of filing, does the AC-21 law applies? What he means to say is that can he change the employer after 6 months of filing the 485 application if he uses the date of filing? The answer is yes. Luckily, yes. That is good. You can change it. The final action dates don't have to be current for you to change the company from company A to company B while the adjustment of status is pending. Before you get the green card, you can change it. Absolutely not a problem. Question from
oh, sorry.
Yeah, question from Ricky. What about the CBP, the Customs and Border Protection, when the government is shut off? It's an essential thing. So there may be some limited, there will be some problems there, but not completely shut off. The complete airports and everything will not be shut off. But there may be some limited limitations. The lines might go much longer than they normally do. That I have seen that when, I think so last time it was in the Clinton time, the lines went up in airlines and everywhere much longer. In CBP also there is a chance that they may have longer lines than normal.
Magnus went from an F1 to a cap exempt H1B, and she's going for stamping for the first time and wants to know, does it have to be in her home country in India, or can she go to Canada for the stamping? So generally, since COVID, with all the consulates reopened, you can apply in any consulate that will accept, that has appointments available. I haven't seen very many people go in Canada. I think they still may be limiting to Canadian citizens after COVID, but we definitely are seeing people go in Mexico again. But just in general, you're not limited to only go in your home country. You can apply anywhere as long as you're legally in that country.
Krishna is a physical therapist in EB2. His priority date is May 2025. I don't have any PhD research or any papers. Is there any way I have 11 years experience, can I just qualify for EB1? That's a question you want to ask. Just because you don't have a PhD doesn't mean that you're automatically out of EB1. Just because you don't have the papers written, you're not automatically out of EB1. There are 10 categories, and you have to qualify for 3 out of those 10 categories. So, but there are certain things like high remuneration. Physical therapists, they don't get high remuneration normally, because I know my wife is one of the physical therapists. So it just because you have 11 years experience, will it qualify for EB1A? Definitely not. We're going to release the video tomorrow. I want you to watch that video. Mr. Ryan Wick, our partner, Emily's and my business partner, he made a good presentation on that. You may want to consider it to see what are those 10 points. Just because you don't have a PhD doesn't mean that you're automatically not qualified. Look into those things and see if you marginally think so you may fit. You may want to discuss with Ryan on that. And that video will be, we already recorded it. It's going to be published tomorrow.
Praveen has applied for his H-1B extension, but never got the receipt notice. But he was able to get the receipt number, likely from the filing fee check being cashed. And now wants to file the H-4 EAD extension for his spouse. And he wants to know if he can file the H-4 EAD extension without having the H-1B receipt notice. Yeah, you can definitely file it. It's not going to cause the H-4 EAD to be rejected in the mailroom or not processed or anything like that. You may eventually get a request for evidence on the H-4 EAD asking for a copy of either the receipt notice, more likely the approval notice of the H-1B. But there's definitely nothing stopping you from at least filing the H-4 EAD extension.
If you got reported to a professional board, an ongoing investigation, will my I-140 485 be approved? Well, you're innocent until proven guilty, Mr. Zoomer. So let's say you have a doctor license and somebody complains against you. It's still under investigation. I don't know what profession you are, but most probably in some licensed professional, like lawyer, doctor, somebody, physical therapist. So just because there is an investigation does not automatically disqualify you from getting the I-140 approved, does not automatically get you disqualified from the I-485. This is not a criminal investigation. This is just a professional board investigation. Now crime has been, you are not being charged with any crime or anything. So it should not hamper in getting I-140 or 485 approved.
Chinton had his I-765, that's the EAD, approved back in April, but he never received the original card. opened a case online with USCIS. They said they're going to resend it, but it's been more than a month and he still has not received it. So we are now in September, and this was approved back in April. Refile it. Don't wait for USCIS to resend it. We see tons of delays in that. They'll tell you that, yeah, we'll resend it, and then all of a sudden 6 months later they say, well, the original was never returned back to us, so we can't issue a new one, so you're just going to have to refile. So I would recommend don't wait any longer, just refile it, get it over with.
Syed has this question: if the H-1B is not picked, is PhD a safer option? Yeah, probably yes. That's definitely a way to stay in the United States and pursue your aspects of staying in the United States. Definitely yes. Mihir is asking the question: what are the chances of the third lottery? We suspect it's very high, but we won't come to know because the deadline to file the H-1B is until October 30th. So somewhere in the November month, we would be able to find out if the third lottery is going to happen. We are expecting it to happen, but we don't know if it's going to happen. That will be decided in November.
Sir says, I'm visiting India and got laid off on H-1B. I don't have an approved I-140. What benefits am I eligible for? You know, because you're outside the U.S. and you've had an H-1B before, I'm assuming you have not reached your 6-year limit yet, you still are eligible to get an H-1B without going through the lottery. So you can search for another employer. Once you find one, they can file a new H-1B for you that does not have to go through the lottery. They can file it any time of year, and they can get that approved for however many years you have left towards your 6-year limit. Then you can get that visa stamped and come back to the U.S. Or if you already have the valid visa from your old company, even though you're not with them, if that visa has not expired, you can use that valid visa with your new company's approval notice to get back into the U.S. That's really going to be your main option there. Otherwise, you can stay outside the U.S. for 1 full year, and then that opens up the possibility of starting your 6-year limit over again, but only if you go through the lottery again.
Amit is asking the question that if I file a concurrently filed H-1B and work for 2 companies, will the USCIS give any problem? No, the USCIS is approving it for you to do it. We're not expecting any problem if you work for 2 companies. So no. Gorus from YouTube asks this question: in the 485, can the biometrics be waived because they have taken it for some other H4, or probably at the time when you entered into the United States, or when you restamped in when you were coming in? Yeah, we see biometrics getting waived when they have any biometrics available on their file. Though we see them very frequently waiving the biometrics for the 485 applicants.
Of course, you still have to pay for it, even though they're not doing it. There's a class action on that pending right now, so hopefully they win that, because that is ridiculous that you have to pay $85 for the government to say, oh, sorry, we don't really need this, and then they keep the money. How many millions of dollars have they made off of that? It's ridiculous.
Yeah.
Govinda says, my mother's I-539 application was denied due to non-availability for the biometrics appointment, and she returned to India in March 2021. Her visitor visa is supposed to be valid till 2028. Can she enter the U.S.? So I'm assuming the I-539 application was for an extension. Maybe during COVID, she got stuck here. Her B2 was expiring, so she filed that extension and then left before the biometrics or something like that. And then the I-539 gets automatically denied. So that is considered technically sometimes by consulates to be an overstay because she never actually got the B2 extension approved. And generally an overstay will void a valid visa. So my recommendation would be, even though she does have the visa stamp in her passport, have her apply for a new visitor visa and then come in, because you don't want her to be at the port of entry and at that moment them say, nope, your visa is not valid, and they send her back.
A question from Case. H-1B is approved. It's been 11 days. The attorney has not received it. Don't panic. Just wait for one more week. It's very normal. Deepak has this question. Will the I-140s be affected due to the shutdown? We are not expecting I-140s to be affected. The reason is that it's self-funded. That means the filing fees that you're paying is running the USCIS. So you should not have any trouble.
MD Offshore says a person being on the grace period who got a new job and filed the LCA with the new employer, what is his situation? Is the grace period stop? So just the filing of the LCA doesn't do anything. So you're still ticking clock for your 60-day grace period. It's the filing of the actual H-1B petition with USCIS. So that petition has to be filed by day 60. Otherwise, you'll go out of status. So we would recommend filing a change of status to some other visa category if you're at risk of running out of your 60-day grace period.
A lot of questions are coming with people whose strategy date is current and they did not get the green card. At this point of time, either they've been interviewed or they still did not get the green card. Now, my advice to those people is that if it's been more than 18 months, the 485 has been pending, sue the USCIS. The reason is that if you don't, what if the dates go back? Are you going to stay there for a long period of time? Since it's been more than 80 days, we recommend that you contact Stephen Brown in our office. He can take a closer look into it and advise you whether it's worth for you to take the litigation or not. Mohan Singh has a very interesting question, though, very tough question too, that he completed 5 years of H-1B. I'm just summarizing this, Mohan, not exactly the way you have. He has completed 5 years of H-1B. Now he wants to go to India, stay in India for, let's say, after 1 year for staying in India. Can he apply through the H-1B lottery again after staying 1 year outside the country? The answer is simply yes, you can apply through the lottery as long as you stayed more than 1 year outside the country. However, Mr. Mohan Singh, I would advise you that while you're in India, if you can find a company to file the labor certification, get an I-140 approval, that will solve the problem of going through the lottery. You know, you may have completed 5 years and 5 months though, and you don't, or 6 months, and you don't want to come for the 6 months here in the United States. But if you try to get a labor certification I-145 while you're outside the country and get that thing pending for more than 1 year, then you're eligible for the H-1B beyond 6 years. And if you get an I-140 approval, you can still get into the country beyond that. Because otherwise, going to the lottery is a big problem. You have only 1/5 chance of getting into the lottery.
Kaluru says, can I change the status for my daughter from H4 to F1? Her H4 is valid till 2026. She's got the I-20 that's valid from December 2023, and she's studying in her second year. And can I apply in premium? What date can they give the F1? So she can file an I-539 to change status from H4 to F1. She needs an I-20. For the upcoming start of the next available semester. And then she can apply in the premium processing. Just be aware, even with premium processing in that 30-day processing time, the clock doesn't start until after biometrics are done. And biometrics can take up to 3 weeks, possibly even longer, for them to issue that, have them taken, and then applied to your case. So really you want to plan on it taking probably 2 months to get the approval. She can continue to study and take her classes while she's on H4 while the F1 is pending, since her H4 is valid until 2026.
H4 EAD, automatic extension. Do we have the automatic extension? There is a small hiccup there. I just want you to understand that. There is no automatic EAD extension of 540 days or 180 days at this point of time. If your H4 is extended and then your H4 EAD extension is pending though, at that point of time, the automatic extension comes in. If both H4 and EAD extensions are pending and the H4 is not approved, then the automatic extension does not work. There are many tricks and trades to get the H4 extension. There are where you can go outside the country, get the stamping. You can go to Mexico and come back, extend the I-94. There is a video we made on it, but if you want, you can have a consultation with any of the lawyers. We will explain you more clearly. But not automatic, only if the H4 is extended, then you have. Praveen has an interesting question. His kid is turning 21. The kid has a EAD and AP. For the Child Service Protection Act to be kicked in, does he need to do any steps for it though? Does he need to apply any application? Does he need to pay any fees? I'm assuming that your child is protected under the Child Service Protection Act, which probably, Praveen, you know what that is. If not, watch one of the videos that we made on it. Now, if he is protected and the kid is protected on that though, then you don't have to make any steps to activate the CSPA. Just print out the online thing. You need to have 4 things. 1, the kid must be under 21, CSPA age calculation, which you know what that is. The I-140 must have been approved. The 485 application must have been filed. The dates have to be current. So for all these things, you print out those things like the visa chart, the I-140, the 485 receipt notice, and the kid's date of birth certificate. You put them in there, put them in the record, and that's it. You don't have to keep. Praveen says the child meets the CSP requirement. You don't have to submit any of these 4 things. What I said to you, Praveen, you can just keep it with you, just in case if at any point of time when anybody asks how is it protected, then we are going to look at the printout of all those things. It's easy to print out. You can go online to get the printouts. You don't have to have a consultation with a lawyer. As long as a child is protected under the CSPA, you just have a printout and keep it. You don't have to submit anywhere to anybody.
Another CSBA question. Swati has a pending I-485 and wants to know if she needs to worry about her daughter turning 21 soon, or is her age already locked until the green card is actually issued? So for a lot of people who already have the 485 pending, most, I would say now, under the current interpretation of CESPA, the age is locked. But there's one situation where people might not have the age locked, and that is for those people that filed the I-485 along with an I-140. So these were a lot of people in October 2020 that did the downgrade. So they filed the 485 and I-140 together when the date was current, but then the Child Status Protection Act does not kick in until the I-140 is actually approved. So if by the time the I-140 got approved, the priority date went backward and was no longer current, your child's age would not be locked in yet until the date becomes current in the future. So that's one thing to think about. Definitely you can check in to make sure. You can schedule a consultation, go to the USCIS Child Status Protection Act page and follow through that to see if she qualifies. But if you want to be sure, you can always schedule a consultation. But that's that one area where if the I-140 took a long time to process and by the time it got approved, the date retrogressed, there may be a problem there.
Krishna has this question. Can I file a H4 plus EAD along with the amendment H1B application? Absolutely you can. And you can file in premium processing as you suggested, and H4 and EAD would be approved along with the H1B. We do that normally though. At the time when you file an amendment, you can also file amendment plus extension also, you can do that. Santosh has this question. He has his I-140 approval, and I'm assuming that it's more than 6 months, and he's contemplating on changing the job right now. Does he need to get the I-140 approval with a new company immediately? Absolutely not required. Unless you're assuming that the priority date is going to become current though. You don't need a new I-140 approval. So if you get an I-140 approval with company A, you move to company B, you can extend the H1B with company B based on the company A's I-140 approval, assuming it's not withdrawn within 6 months. You can extend the H1B from company B, you can extend it. You can move from company B to company C, you can move from company C to company D, and so on and so forth using company A's I-140 approval. That's all you need. Now, what about the spouse's H4 EAD? Do you need to get a new I-140 approval with company B? The answer is no, you don't need it. you can still use company A's I-140 approval to extend your wife's EAD or file your wife's EAD.
Mahi got a birth certificate affidavit on stamp paper and wants to know if that works or if it needs to be on white paper. So whether it's stamp paper or white paper, either one is fine for an affidavit of birth. But what you do need to be aware of is that document by itself is not enough to get the green card approved. You can file the 485 with that, but you are going to also need a non-availability certificate from the location where the birth should have been registered. This is coming from the government saying the birth was never registered. And then you have your affidavit to go with that. And then they'll want secondary evidence, which is usually something from your school, something from a doctor, something, the oldest possible records you have that would have your name and date of birth on them.
Question from Vamsi: is there any issue going with the consular processing on the STEM extension with the H-1B visa approval? Yes, because technically, if the H-1B is approved with the consular processing, it is not counted towards the H-1B number. It must be stamped in the passport, or you must convert back into with the I-94. Then only it's technically counted toward the H-1B number. Now, what happens is that it's a consular processing. What if you lose the job? What if you don't get the stamping? A lot of things can go wrong in that period of time. Just because you want to save that little bit taxes, you don't want it. Believe me, there are so many people who cry and whine choosing that option. It is not worth it. You can make the money. You don't have to risk your H-1B status, because if you don't get the lottery, then it's going to be a major problem for you at a later date.
SK says it's been more than 180 days after I-140 approval, and he's got a great offer from another company. How safe is it to move without hurting the I-140 approval? Well, it depends on what you mean by not hurting the I-140 approval. So once it's been 180 days, it's true that that I-140 cannot be withdrawn by the old employer when you leave the company. Now, technically, they can still withdraw it, but you can keep using it for continued H-1B extensions and H-4 EAD renewals for your spouse, like Rahul mentioned earlier. But what you can't use it for is to actually file the I-485 application. So in that sense, yes, the company can still hurt your I-140 approval because you can't use it to file for the green card, but it is safe to leave that company and use that I-140 even after it's been withdrawn to get the H-1B extensions and the H-4 EAD. You do have to go through new labor certification, new I-140 at some point before your date becomes current.
Sandeep has this question. He applied F2A green card for his wife, family-based preference, second category A, and the priority date is not current. The final action date is not current, and he is documentally qualified for the green card. But can she apply for the B2 visa as the priority date is backlog to come into the United States? No, she cannot. The reason is B2 visa is only to come temporarily into United States, not to permanently stay in United States. Since she has an I-130 and documentary qualified saying that she wants to come in United States permanently, if she applies for B2 visa, though, it most probably will be rejected, though, because in the DS-160 form, you have to mention all these things and it will be rejected. Now, the question that comes out from Ashish Gandwa answers this question, actually. The question what Sandeep asked, Ashish Gandwa is asked this question. I am a permanent resident. I recently got married. My wife applied student visa a couple of times, refused. She's on Canada, she's on Canada in a student visa. How can I bring her in USA? The fact that you got married, though, actually would be a very good reason to deny for the F1 visa. Because when they are looking into the F1 visa application, they are looking into if she is going to go back to her home country after she completes her F1 visa. Since she is married to the green card holder, there is a higher probability, and he's living in United States, there's a higher probability she is going to go and settle in United States. And that's the reason why most probably the F1 will be rejected, though. There is no way out. You have to file an I-130 application, and the I-130 application, and then apply for the and then do the consular processing, like what Sandeep has done, though. Now, here is where some people need to understand, though. If the person is in United States on a F1 visa or a B2 visa, if they get married to the green card holder, they can file for the green card application, not a problem. But they can stay in United States, especially if they are an F1 visa, though. Now, if they are outside the country and they get married, they want to come on a B2 or F1, that is a problem, though. If they are in United States, you get married, that's not a problem. But when they're outside, it becomes a problem. There is a wait period. Sometimes the wait period may be 4 years, 3 to 4 years for them to get the green card.
Clevy26 says, if the PERM has been pending for 1 year and my H-1B max out date is January 2025, can I file for the 1 year extension right now? If not, when is the earliest I can file? So it partly depends on when your current H-1B is expiring. So if your current H-1B is expiring January 2025, and that's also your 6-year limit, it's too early to file your extension. You would normally have to wait until 6 months before it's expiring. And at that point, if your PERM is still pending, you can get the 1 year extension from there. However, let's say today is September 2023, your current H-1B expires in January 2024, but your max out date isn't until January 2025. Now you could file your extension of your H-1B to reach your 6-year limit and add the extra year because your PERM has already been pending for 180 days, or I'm sorry, for 365 days. So it all depends on when your current H-1B is expiring. One other thing, if you are kind of in that first situation where your H-1B currently is expiring January 2025, and that's also your max out date, so it's technically too early to file, but maybe there's a concern that your PERM might get denied. Maybe the reason it's pending for 1 year is because it's been audited and you're not sure it's going to get approved. You may want to file the extension of your H-1B early to buy yourself more time to get that 1 extra year now, so that you could potentially refile a PERM or have time to do that. So how do you do that? Your employer could actually file now as an amendment plus extension. So an amendment, you don't have to wait till 180 days before it's expiring. You can file that at any time, and then you can add extra time on the end to that. So that's one trick that can be done if you need to file that extension now, even though technically you're not eligible for it.
This question comes from Maggie. She is on TN status until 2025, won the H-1B lottery. The employer is hesitant. The EB3 became current in October. Can I file the adjustment of status and H-1B at the same time? Will it cause any problem filing both the applications at the same time? The answer is, yeah, absolutely. You can file adjustment of status and H-1B at the same time. Will not create any problem. Whether or not you should remain on TN visa is a question of interpretation. It's up to you because you have until 2025. I don't see any reason for you to move on to H-1B, but some people want to insist that they want to maintain the non-immigrant status until they get the green card. If that you belong to that particular class, you may want to move on to the H-1B. The reason is that you cannot extend the TN visa once you file the green card 485 application.
Krishna says, is it mandatory to do an amendment if the H-1B company got acquired and the new company has a different name? Generally, no. So in the event of an acquisition, usually the surviving company that maybe has a different name is considered a successor in interest, meaning that it is taking on the interest of the original company and continuing to operate. So in that situation, it does not require an amendment to be filed. It doesn't require a transfer to be filed. The company just has to add some extra documents to its public access file. That's even if your visa stamp has the old company name on it and your pay stubs now have the new company name. Even if you need to go for visa stamping, even if you're traveling, everything remains valid with respect to that new company name. We generally will issue kind of a letter explaining the acquisition and how the company qualifies as a successor in interest and what the old name is and what the new name is. And our companies will give that to all of their employees that might need to travel or apply for the visa stamp. Never had any issues with that.
Question. My prior date is 2014. I have a previous I-140 approval. Now I'm with a different company. Didn't file the 485 application. Now I got the PERM approved. Should I file in premium processing or normal processing? I would file in normal processing. I will not file in premium processing because what are you going to do with the I-140 approval? It doesn't do anything good for you. So I'm not that hurry in getting the premium processing approval. Sunita Pathak has this question. I'm a petroleum engineer, Bachelor of Science in Petroleum Engineer. There is a lot of shortage in petroleum engineer. Can I file NAW because of the shortage of the skills that are there? Just because the shortage of the skills are there, you're not automatically eligible for non-national interest waiver. When there is a shortage of the people, though, that's what we call it as EB2 and EB3. That's where we file the labor certification saying that there is no Americans available for these kind of jobs. That's where we get the EB2 and EB3 approved in the labor certification. For the national interest waiver, it's a different qualification. I want you to watch the video that we are going to send it. And Emily, can you give the link that you said about the kids that need to be educated by the people who are the legally documented kids?
Yes.
We're going to provide the link for the children to become members of this organization who are in the teenagers so that they can get educated. We'll provide a link. By tomorrow, we're going to provide a link at the bottom of the link, at the bottom of the video. Anything else, Emily?
Oh, I didn't realize it's time already. Thanks so much for joining us. We'll be back again next week. Please remember to subscribe to our YouTube channel. If you're new here, click that subscribe button. That way you'll be notified whenever we go live and whenever we update any new videos. We do have a lot of little short videos that we upload that give quick topics that we go over and answer questions there. And you can always subscribe to our newsletter as well by going to rnlawgroup.com.
And you can make an appointment with me or Emily. Our schedules are available online. You can also make an appointment with our colleagues. You can go to rnlawgroup.com or the link is provided there to make an appointment with me, Emily, or anybody else in our office. Thank you very much for tuning in.